Here to talk now more about the significance of the case is Andrew Lieb, a constitutional lawyer. Andrew, thank you for being here with us today. As always, appreciate your time. First, want to get your initial thoughts on the ruling. Is it what you expected? Have you read it enough to kind of be able to parse through how the decision was made?
I like your idea of my speed reading. It's 237 pages, so it's going to be a
read
little
it
while,
enough
but,
was the key part. Read it enough.
The key thing that we take, and which we're hearing from everyone, is that a race plus can no longer be a factor in decision making for universities. In plain English, that means that we were never allowed to have race be a quota system. That we knew was not allowed. But there was a Supreme Court precedent. It was called a Bakke decision. And then they had a Grutter after that, two different decisions that basically said it could be a plus factor. Could we consider race at all? And what we've learned now is under the Equal Protection Clause, that's in the Constitution, that would be discriminatory. You can't do that. You can't make race a factor, and it's going to be changing the way admissions happens overall. Also, when it comes to not just UNC, which is a public university, Harvard, a private university, is applicable also with Title VI, which means they receive federal funds, and Gorsuch writes a concurring opinion about it. But in plain English, what we learn is that you are no longer allowed to make race a factor in admissions, and it's going to change the education system in our United States overall.
And I'm curious to get your thoughts on the dissent. Judge Ketanji Brown Jackson accusing the majority of, quote unquote, let them eat cake obliviousness. What are your thoughts on the dissent and the thoughts in regards to deeming race irrelevant to these kind of decisions?
So I think it's a great quote. I think we'll get into the quote, but I first have to point out that there's two different cases, and Judge Jackson did not rule on one of the cases. She only dissented on one of the cases. The other one, she didn't rule either way on it, which I thought was interesting in and of itself. But I think that this is a major problem, and we go back to the oral arguments. And in the oral arguments, one of the most striking, I'm paraphrasing, questions was, how are you ever supposed to have an application essay? You know, if you have a kid or you applied to college yourself, you would know the whole thing is this essay. How do you write an essay and make it race blind? How do you do that? How is the system going to moving forward? Because if someone had race be a factor, they worked at a nonprofit that did racial discrimination, how does this work moving forward? So, you know, whenever they say you solve a problem, you create a new problem. So that's going to be the next front that we're going to have to find out. But the liberal justices, Judge Jackson, we have Sotomayor. These justices, they're concerned because at the end of the day, how are you going to lift up people? But I'm going to leave you with a cliffhanger now. Malcolm Gladwell, a very famous author, suggests that when you do this, you might actually be hurting the people that would otherwise not be getting in, because the long-term effects of being the best in a lower institution are often better than being the worst in a higher institution. So maybe it's actually for the better of the minority people that would no longer be getting in. Just an interesting intellectual thought.
No, that is an interesting point. And this all brings up the question of how this actually will be handled in the upcoming admissions year, perhaps next year. Is it clear at all in the ruling just how fluid making these kind of decisions could be? As you mentioned in an essay, it's going to be hard to avoid understanding someone's background, especially if they make it a point to put it in their essay, or if you're able to kind of glean from the essay something. How does that get ruled on? Because at the end of the day, that is something that might not come to consciously.
You nailed it. And I think we're going to have a lot of litigation moving forward, because what do these mean? Like, you're right, 237 pages, but maybe it needed 2 million pages to understand exactly what to do moving forward. And like I started this conversation, I haven't read and studied every word of it, but there's a thing about them being race conscious, and there's a thing about the applicant being race conscious. How do those two roles play into each other? And then I'm just going to throw your head to another spin. But you know that Title VII, which is about employment discrimination, or when we talked about Title VI before, or Title VIII, which is housing discrimination, Fair Housing Act. How does it work when we're dealing with DEI, diversity, equity, and inclusion in these other realms now? And how do we take from this type of discrimination about the Equal Protection Clause moving into these other realms? And how do we prop up people and help them get forward, if even that's a goal. So I think there's going to be a major shakeout from this. There's going to be lots of lawsuits that come next from this. But at the end of the day, proof is going to be the key. How are you going to see if a school took into account or went too far in taking into account a race-conscious essay? And the standard there is going to be a case-by-case basis. So I think they made things simpler, but actually they made things more legally complex.
And is perception a big part in all of this? Because according to many polls, Americans do not favor race being a factor in admissions, both Democrats, Republicans, and independents. So is this more just about the knowledge that race is a factor versus it actually being a factor in those individual moments?
In society over years, we go in waves. Once it's like, give more rights. Then it's, but what about the majority? Now they're the minority. Oh, give more rights. But what about the majority? It goes back and forth, and we're on a wave right now about reverse discrimination. Since DeSantis with his anti-woke campaign, he does it. At the end of the day, we're in an era right now about reverse racism. And if you try and prop up people that were historically underrepresented or systemically discriminated against based on history, maybe you're discriminating against other people. And I think the real issue is that both sides need to acknowledge, and I hope this would settle everyone down, that there's not a right answer. It's not simple. It's messy. Engaging with other people is messy. Whenever you talk to anyone, everyone has their own story, and it's messy. And their help doesn't hurt me, and my help doesn't hurt them. But at the end of the day, yes, I think the culture definitely played a major factor in this. I think we're in the climate right now for this decision today. Just like when Grutter, the precedent decision on this came out, we were in a climate differently. I'll leave you with this thought, though. Grutter said maybe in 25 years we'd be in a different climate. So I'll tell you today, maybe in 25 years we'll be in yet another different climate.
I will hold you to that one, because it does feel like things are just, the pendulum swings back and forth every few years. All right, Andrew Lieb, constitutional lawyer, thank you so much for being here and breaking that down with us.
Thank you.